Hello Year 12s and welcome to this video in which we look at two more factors that affect the ability of the courts to make law, that is, judicial activism and judicial conservatism. There are four things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what to include in your summary books. And the fourth thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you're unfamiliar with. Once you've finished watching this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information.
Well, let's get started then.
This is the second in a series of 3 videos about the factors that affect the ability of the courts to make law. I've listed the factors that we'll be looking at in these 3 videos on this slide. In this video, we are looking at judicial activism and judicial conservatism. Accordingly, your learning intention for this video is that you should be able to discuss how judicial activism and judicial conservatism affect the ability of courts to make law. Make sure that you write this learning intention down in your Cornell notes. Well, let's start off with the definitions of judicial activism and judicial conservatism. Judicial activism is where judges make a major or controversial change to the law and base their decisions not just on legal considerations, but also on social and political values. Look down the left-hand side of your vocabulary sheets, find the term judicial activism and include this definition in there. Once you've written the definition, please highlight the words in red, bold, italicized type. And if ever you need to describe judicial activism, make sure that you include the highlighted words in your description. In contrast, judicial conservatism is where judges are cautious about making a major or controversial change to the law and base their decisions only on legal considerations. Look down the left-hand side of your vocabulary sheets, find the term judicial conservatism and write this definition in there. Once you've done that, highlight the words in red, bold, italicized type. And if ever you're required to describe judicial conservatism, make sure that you include these highlighted words in your description. Can you see the difference between judicial activism and judicial conservatism? Judges who are judicial conservatives base their decisions only on legal considerations. However, judges who are judicial activists base their decisions not just on legal considerations, but also on social and political values. Let me now illustrate what the concepts of judicial activism and judicial conservatism mean by looking at the Mabo case. Up until 1992, it was part of the common law that when the British settled Australia, the Crown, that is the King of England, took ownership of all of the land in Australia. This was because the British treated Australia as being unoccupied when they settled it. In legal terminology, Australia was considered to be terra nullius, that is, uninhabited land. Now we know that, as a matter of fact, Australia was not really uninhabited. On the contrary, Australia's indigenous people were already living on and using the land. However, the British took the view that Australia's indigenous people were savages who could not possibly have any rights to the land that they lived on. Put bluntly, the British treated Australia's indigenous people as being no more than wild animals like the kangaroos and emus, and kangaroos and emus clearly have no right to the land that they roam over. Of course, we know that this is not true. On the contrary, we know that Australia's Indigenous people did have a very strong connection with the land that they occupied. They used it for hunting, gathering food, and performing social, cultural, and religious rituals and ceremonies. But, like it or not, 200 years ago, the British took a different view. The consequence of this view was that the Crown, that is, the King or Queen of England, was free to do whatever they wanted with all of the land in Australia, because the Crown owned all of this so-called unoccupied land. And one of the things that the Crown did with lots of this land was to transfer it to the settlers, who then drove Australia's Indigenous people off the land that they believed that they, rather than the Indigenous people, owned. In the Mabo case, the plaintiff, Eddie Mabo, argued that the High Court should change the common law to recognise that Australia's Indigenous people did have rights to land when the British settled Australia, and that these rights have continued in existence. Eddie Mabo first brought his case to the High Court in 1982, and it took 10 years for the High Court to deliver its final judgment in this case in 1992. 6 out of the 7 High Court judges who heard the case decided in favour of Eddie Mabo. Remember that for over 200 years it had been the common law that when Australia was settled by the British, Australia's Indigenous people had no rights to the land, and so the Crown took ownership of all of the land in Australia. Well, in 1992, the majority of the High Court changed this law. They decided that Australia's Indigenous people did, in fact, have rights to the land when Australia was settled by the British, and that in some circumstances these rights continued in existence after settlement. These rights were called native title and entitled Australia's Indigenous people to use the land for their traditional purposes such as hunting, gathering food, and performing social, cultural, and religious rituals and ceremonies like corroborees. According to the majority of the High Court, Australia's Indigenous people continued to have these rights even when the Crown transferred the land to the settlers, unless the use of the land by the Indigenous people for their traditional purposes was inconsistent with the use of that land by the settlers. So, for example, if the settlers used the land to build a house, it would clearly be inconsistent with the use of that land for a house for the Indigenous people to still have the right to use that land for their traditional purposes. For instance, it would not be possible for the Indigenous people to hunt kangaroos on land which had a house built on it. In such a case, whatever rights the Indigenous people previously had to that land were extinguished. That is, those rights ceased to exist. However, if the settlers instead used the land for farming, it would not be inconsistent with the use of that land for a farm for the Indigenous people to continue to have the right to use that land for hunting kangaroos. This is because the same land can be used both for grazing sheep or cattle and for hunting kangaroos. In such a case, the Indigenous people would continue to have the right to use the land for hunting kangaroos. The decision of the majority of the judges in the Mabo case is an example of judicial activism. This is because these judges made a major change to the law based not just on legal considerations but also on social values. More specifically, the majority of the High Court recognised that, consistently with today's social values, it was not appropriate to treat Australia as being uninhabited when it was settled by the British. That is, it was not appropriate to have treated Australia's Indigenous people as savages who had no rights to land. Instead, it was appropriate to recognise that Australia's Indigenous people were capable of having, and did have, rights to the land when Australia was settled by the British.
As you'll recall, our learning intention for this video requires you to be able to discuss how judicial activism affects the ability of courts to make law. The table on this slide sets out in the left-hand column how judicial activism contributes to the ability of the courts to make law, and in the right-hand column, how judicial activism detracts from the ability of the courts to make law. Please include this table in your summary books, and as you listen to the discussion which follows, make such additional notes on the table as you think will help you to better explain the points made in this table. Judicial activism contributes to the ability of the courts to make law because it means that judges can decide cases in a fairer way, as they take into account a range of social and political values. In particular, a judge who is a judicial activist will make significant changes to the law where this is consistent with current social and political values. We've seen this in the Mabo case, where the majority of the High Court decided that it was inconsistent with current social values to regard Australia's Indigenous people as having no rights to land in Australia when Australia was settled by the British over 200 years ago. There is little doubt that when Australia was settled, the view was that Australia's Indigenous people could not have rights to the land because they were considered to be more like animals than humans. Of course, this view was the result of ignorance and prejudice. Just because the Indigenous people didn't use the land in the same way as the British didn't mean that they did not have any rights to the land. However, for better or worse, that was the view at the time. This view is clearly inconsistent with current social values, which do recognise that, in retrospect, Australia's Indigenous people did have a strong connection with the land. The majority of the High Court demonstrated judicial activism because they made a major change to the common law by overturning the legal position that had been accepted for more than 200 years that when Australia was settled by the British, the Crown took ownership of all the land in Australia and the Indigenous people had no rights to that land. In reaching this view, the majority of the High Court clearly took into account current social values, which recognised that Australia's Indigenous people had, and continue to have, a strong connection to the land, and that their rights to the land, as Australia's first inhabitants, should be respected. So it is that by being judicially active, a judge can keep the law up to date. A judge who is a judicial activist will also interpret statutes broadly so as to protect individual rights. For example, in the Roach case, we saw that the High Court interpreted the Constitution in a way that protected the right to vote, even though the Constitution didn't expressly include such a right. This is another example of judicial activism. Finally, Parliament does not have the time to keep all of our laws up to date to deal with new situations or to deal with changes in society's values. Indeed, Parliament is unlikely even to be aware of all the changes that need to be made to the law for these reasons. However, a judicially activist judge might be prepared to change the law. In these circumstances, an advantage of judicial activism is that judicially activist judges can keep the law up to date where the primary lawmaker, that is Parliament, does not have the time to. Of course, a judge cannot change the law unless the judge is deciding a case where it is necessary to decide what the law that applies to that case is. So this is a significant limitation on the ability of judicially activist judges to keep the law up to date. However, there are some disadvantages of judicial activism, at least where judges change the law in controversial ways. The main issue with judicial activism is that if judges make controversial or inappropriate laws, then there is a risk that the community will lose respect for judge-made law. While it's appropriate for Parliament to make new and often controversial laws, there are significant differences between the courts and Parliament that mean that judges have to be very careful in making new and controversial law. First, unlike Parliament, judges are not elected by the people, and so they cannot be removed from office if they make law which the majority of the people disagree with. Second, unlike Parliament, a judge's social and political values do not necessarily reflect the the social and political values of the community. As you know, Australia's parliamentary system is based on representative government, which means that the members of Parliament are elected by the people and so should make laws that reflect the views and values of the community. If they don't, then they're at risk of being voted out at the next election. However, a judge is just one person, and there's no guarantee that a particular judge's social and political values will reflect those of the community. On the contrary, judges come from a particular demographic. They're well educated, well paid, white, and often older men. They're not typical Australians, whatever that may mean. Third, unlike Parliament, judges are not able to consult the community before changing the law, and they don't have the resources to investigate the consequences of making a significant change to the law. This may mean that they make an inappropriate law. For example, in the case of Dietrich and the Queen, the High Court decided that a judge could generally stop a trial if the accused had been charged with a serious offence and wanted but could not afford and could not obtain legal representation. In such a case, the High Court held that the trial should not continue until the accused was provided with legal aid, because it should be presumed that an accused who had been charged with a serious offence could not have a fair trial unless they were represented by a lawyer. This was a fairly significant change to the existing law, which, up until that point, had accepted that the fact that an accused was not represented by a lawyer did not necessarily mean that their trial was unfair. This decision had serious consequences for the legal aid system because it meant that a large amount of legal aid money that was being used in family law cases now had to be diverted to criminal law cases. While this ensured that accused people received a fair trial, it prejudiced the ability of women to obtain legal aid to assist them in family disputes, which often arose as a result of those women being trapped in an abusive relationship. The upshot of all of this is that while judicial activism does have the benefit of enabling judges to decide cases in a fairer way, it does have the risk that the community will lose respect for judge-made law if the judge changes the law in a controversial or inappropriate way. Another way in which judicial activism can detract from the ability of the courts to make law is that it leads to unpredictability. People will have relied on the existing law in making decisions, but if a judge changes that law, then they might need to make costly changes to what they're doing. For example, suppose that the existing law was that an employer is not liable to an employee where that employee is injured as a result of another employee playing a prank on the employee at work. If a judge hearing a case changes that law to make employers liable to their employees where those employees are injured as a result of another employee playing a prank on them at work, then employers will need to put in place additional rules and procedures to regulate and monitor the behaviour of employees in the workplace, and will need to pay for insurance to protect them against this new liability. And finally, if a judge changes the law in a significant way, then it's likely that the party who's relying on the existing law will appeal that decision to a higher court. This will be costly and time-consuming for both the appellant and the respondent.
There was one High Court judge in the Mabo case who disagreed with the other judges. The name of this judge was Justice Dawson. His approach is an example of judicial conservatism. This is because he upheld the existing law, that is, he refused to change the 200-year-old common law rule that when the British settled Australia, Australia was taken to be terra nullius, that is, uninhabited. Put another way, Justice Dawson thought that it was inappropriate for the High Court to make such a major change to the law. Now, Justice Dawson wasn't being racist in any way. He acknowledged the appalling treatment of Australia's Indigenous people by many of the English settlers. But having looked in detail at the history of British settlement in Australia, Justice Dawson concluded that it was an historical fact that the British government and the English settlers did treat Australia as being terra nullius, that is, uninhabited, at the time Australia was settled by the British. As a consequence, Justice Dawson took the view that as a matter of law, when the British settled Australia, the Indigenous people had no rights to that land, and the Crown, that is, the King of England, took ownership of all land in Australia. While this decision is not consistent with today's social values, which do recognise the deep connection that Indigenous people have traditionally had with the land, Justice Dawson based his decision only on legal considerations. That is, he applied the existing common law, which was that Australia was treated as being uninhabited when the British settled it. The result of this was that, in Justice Dawson's view, Australia's Indigenous people did not have rights to land in Australia when it was settled by the British. As I say, Justice Dawson wasn't being racist, but he was very cautious about making such a major change to the law by overturning the common law rule that Australia was terra nullius, that is, uninhabited, when it was settled by the British. Justice Dawson took the view that it was for Parliament, not the courts, to change the law in this way. As I've explained in the context of the previous slide, a real risk of judicial activism is that it involves unelected judges making major changes to the law. The issue with this is that, unlike Parliament, judges are not accountable to the Australian people when they make law. They can't be removed from office if they make a law that the majority of people disagree with. And the social and political values of judges do not necessarily represent the social and political values of the majority of the people in Australia. Justice Dawson was very conscious of this, which is why he thought it should be left to Parliament to make a law that recognised the rights of Australia's Indigenous people to land, if that's what Parliament wanted to do. The decision of Justice Dawson in the Mabo case is an example of judicial conservatism. This is because Justice Dawson was not prepared to make a major change to the law by overturning the common law rule that had been in place for over 200 years, that Australia should be treated as being uninhabited when it was settled by the British. In taking this view, Justice Dawson based his decision only on legal considerations. In other words, he applied the existing law to decide the case. As you'll recall, our learning intention for this video requires you to be able to discuss how judicial conservatism affects the ability of courts to make law. The table on this slide sets out in the left-hand column how judicial conservatism contributes to the ability of the courts to make law, and in the right-hand column how judicial conservatism detracts from the ability of the courts to make law. Please include this table in your summary books, and as you listen to the discussion which follows, make such additional notes on the table as you think will help you to better explain the points made in this table. Essentially, the ways in which judicial conservatism contributes to the ability of the courts to make law are the same as the ways in which judicial activism detracts from the ability of the courts to make law. And the ways in which judicial conservatism detracts from the ability of the courts to make law are the same as the ways in which judicial activism contributes to the ability of the courts to make law. Put another way, judicial activism and judicial conservatism are opposite sides of the same coin. The first way in which judicial conservatism contributes to the ability of the courts to make law is that it maintains stability in the law because judges follow established legal principles and don't make major changes in the law based on social and political values that can change over time. In contrast, a disadvantage of judicial activism is that it can result in unpredictability because a judicially activist judge may make significant changes to the law based on social and political values, which, as I've said, can change over time. In addition, the major changes to the law made by a judicially activist judge can impose costs on people who've arranged their business or other affairs on the basis of the existing law. The second way in which judicial conservatism contributes to the ability of the courts to make law is that because judicially conservative judges don't make major changes to the law, and because judicially conservative judges only change the law based on legal considerations, it is much less likely that a party will appeal the decision of a judicially conservative judge. Again, this is in contrast to a disadvantage of judicial activism, which is that there is a much greater likelihood of an appeal against a judicially activist judge's decision because that decision makes a significant change to the law. As I've previously explained, appeals can be costly and time-consuming for both the appellant and the respondent. And the third way in which judicial conservatism contributes to the ability of the courts to make law is that there is less risk of a judicially conservative judge making controversial or inappropriate laws that don't reflect the social and political values of the community or that have unintended consequences. This means that it is more likely that the community will continue to respect judge-made law. In contrast, if judicial activism results in a judge making a controversial or inappropriate law, then the community might lose respect for judge-made law because, unlike Parliament, judges are not elected to make law and their social and political values may well not reflect the social and political values of the community. Moreover, unlike Parliament, judges don't have the resources to investigate the potentially quite significant consequences of them making a major change to the law. On the other hand, judicial conservatism detracts from the ability of the courts to make law because it means that judges will not change the law even where this is desirable. Instead, that is left to Parliament, but Parliament might not be willing to make that change or might not have the time to make that change. Likewise, judicial conservatism detracts from the ability of the courts to make law because it means that the law may become outdated. If judges don't change the law in line with current social and political values, then laws which might have been appropriate, say, 50 years ago, but which have ceased to be appropriate nowadays, will nevertheless continue in operation. An example of this is Trigwell's case, where the High Court refused to change the common law rule that a farmer was not liable for loss caused by the farmer's stock straying onto the road. This rule was appropriate when it was made over 100 years ago because at that time many people were farmers and there were no cars that could speed along highways. However, that rule is no longer appropriate today when most people are not farmers and stock can cause serious accidents if they wander out onto the highway where cars travel at high speeds. In fact, following that High Court decision, the Victorian Parliament did change the law to make farmers liable in negligence where their stock strayed onto the road and caused an accident. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to discuss how judicial activism and judicial conservatism affect the ability of courts to make law. Don't forget to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.